a Federal Judicial Center orientation series for United States bankruptcy judges. Organization and jurisdiction of the U.S. bankruptcy courts. With S. Elizabeth Gibson, Burton Craig Professor of Law at the University of North Carolina School of Law, and the Honorable J. Rich Leonard, United States bankruptcy judge for the Eastern District of North Carolina. Professor Gibson joined the University of North Carolina faculty in 1983 and was appointed Burton Craig Professor of Law in 1993. She received her BA from Duke University in 1972 and her JD from the University of North Carolina in 1976. Judge Leonard was appointed to the court in 1992. He received his BA from the University of North Carolina in 1971 and a Master's of Education in 1973. He received his JD from Yale in 1976. The Eastern District of North Carolina has two authorized bankruptcy judges who hear cases in Raleigh and Wilson.
Welcome to this discussion of the organization and jurisdiction of the bankruptcy courts. During this half hour, we will touch on the following topics: subject matter jurisdiction, reference of proceedings, abstention and remand, powers of bankruptcy judges, jury trials in bankruptcy, and appeals. In general, we will be dealing with the statutory provisions in Title 28 dealing with bankruptcy jurisdiction and procedure, rather than the provisions of Title 11 that contain the substantive bankruptcy law. Obviously, the topics we will touch on cannot be fully covered in this amount of time. In fact, they could provide the content for an entire law school course. Our more modest goal is to give you a conceptual understanding of these basic issues so that you will have a starting point for further analysis when these questions arise in your cases. Also note that the jurisdictional statutes give rise to differing readings, and judges and scholars disagree strenuously on the appropriate interpretation. You will need to make sure you are conversant with existing precedent in your district and circuit.
Congress has conferred federal subject matter jurisdiction over bankruptcy cases and proceedings on the United States district courts. This conferral of jurisdiction in 28 U.S.C. Section 1334 A and B extends to all cases under Title 11 and to all civil proceedings arising under Title 11 or arising in or related to cases under Title 11. The language "all cases under Title 11" refers to the bankruptcy case itself that is initiated by the filing of a petition under a particular substantive chapter of the Bankruptcy Code, and that jurisdictional grant is exclusive. The other categories of jurisdiction conferred on the district courts by Section 1334 are non-exclusive. That is, the federal and state courts have concurrent jurisdiction. The grant of jurisdiction as to these matters was intended to be sufficiently broad to encompass all proceedings that have to be resolved in order to effect the prompt closing of a bankruptcy case. As Judge Leonard will discuss in a few minutes, although Congress conferred bankruptcy jurisdiction on the district courts, it authorized much of this jurisdiction to be exercised by the bankruptcy courts. In order for a bankruptcy or district court to determine whether a particular proceeding falls within bankruptcy subject matter jurisdiction, only the outer boundaries of Section 1334's jurisdictional grant must be considered. For this purpose, it doesn't matter which particular category a proceeding falls within, so long as it's at least related to a bankruptcy case. Judge Leonard, how do courts generally determine whether a proceeding is related to a bankruptcy case?
Generally, courts have given a broad interpretation of the term related to. Under the generally accepted definition, a proceeding is related to if its determination will have an effect upon the bankruptcy case or its administration. Three types of effects meet this test. If the proceeding will determine a claim against the estate, it is clearly related. Similarly, if it concerns a claim that the estate may have that will bring assets into the case, it is related. In both of these instances, the estate is a party to the proceeding, and it's easy to see that the related to test is met. The more difficult analysis comes with the third category, those cases that have an effect upon the administration of the estate. In these cases, the estate is often not a party, but the assertion is made that the resolution of the action between two non-debtors will so affect the estate that it falls within bankruptcy jurisdiction. Suits involving guarantors or joint obligors of the debtor often fall into this category.
Although many proceedings will clearly have an effect upon the bankruptcy estate, and thus will be found to fall within bankruptcy jurisdiction, cases at the margin raise difficulties. Four main problems have arisen in applying the effect upon the estate test. First, it's important for the court to distinguish between the debtor and the estate. To come within bankruptcy jurisdiction, a proceeding must affect the administration of the bankruptcy estate or the discharge of a debtor. If a proceeding only affects other aspects of the relationship between a debtor and its creditors, it's not related to a bankruptcy case and thus not within bankruptcy jurisdiction. Sometimes this distinction turns on matters of substantive bankruptcy law. For example, in a Chapter 7 case, a proceeding by the debtor or against the debtor that arises after the filing of the petition will have no effect on the bankruptcy estate. Any judgment obtained would be neither property of the estate nor a claim against the estate. By contrast, in a Chapter 13 case, a proceeding by the debtor that arises after the filing of the petition will have an effect upon the estate. The Chapter 13 estate, unlike that in Chapter 7, includes property acquired by the debtor while the bankruptcy case is pending.
The second caution that should be noted is that the court must be careful to focus on who the debtor is. To come within the bankruptcy court's jurisdiction, a proceeding must affect the estate of the debtor, the person or entity that filed the bankruptcy petition, and not some related entity. For example, where the debtor is a partnership, an action brought by or against a partner who hasn't filed for bankruptcy will probably not affect the partnership's bankruptcy estate, and thus the proceeding does not come within bankruptcy jurisdiction.
The situation concerning proceedings among non-debtor parties raises the third problem in applying the effect upon the estate test. How likely does it have to be that the proceeding will affect the bankruptcy estate? Does it suffice that the proceeding could conceivably have an impact on the administration of the bankruptcy case, or must a more certain effect be identified? The courts of appeals are divided on this. The Sixth Circuit, for example, has held that mass tort claims against a Chapter 11 debtor's co-defendants will fall within related to jurisdiction because of the potential contribution and indemnity claims by and against the debtor resulting from such actions. The Third Circuit, by contrast, has rejected related to jurisdiction over a suit between non-debtor parties, even though it was likely to be the precursor of an indemnification claim against the debtor. The court reasoned that the proceeding in question would not automatically establish the debtor's liability, and thus the bankruptcy estate would not be affected by the action. Similarly, courts are divided over whether, to fall within related to jurisdiction, a proceeding must affect the legal rights of the estate, or whether some less formal, more practical impact will suffice. Finally, if a proceeding involves multiple claims and parties, the court must be careful to determine whether subject matter jurisdiction exists as to each of the claims. The possible basis of subject matter jurisdiction might be a statute other than Section 1334. For example, 28 U.S.C. Section 1367 gives the district court supplemental jurisdiction. That grant extends to claims not otherwise falling within federal subject matter jurisdiction that are sufficiently related to claims within the court's original jurisdiction to form part of the same case or controversy. Thinking about the possibility of a federal court hearing a claim only because it is related to a claim that is related to a bankruptcy case is enough to boggle the mind. But even if the district court can exercise supplemental jurisdiction under such circumstances, courts are divided over whether bankruptcy courts have such authority. A number of courts have held that supplemental jurisdiction is not within the scope of the jurisdiction that may be referred by the district court to the bankruptcy court, a matter to which we now turn.
As we have already seen, Sections 1334A and B confer bankruptcy jurisdiction on the district court. Section 151 of Title 28 spells out that the bankruptcy judges in any district shall constitute a unit of the district court known as the bankruptcy court for the district. Section 157A then authorizes the district court to make a wholesale reference to the bankruptcy court of all cases arising under Title 11, all proceedings arising under Title 11, or all cases related to a case under Title 11. Virtually, without exception, every district court has done so. At this time, only in Delaware, where Chapter 11 proceedings are currently being randomly assigned among both district and bankruptcy judges, is the practice of complete delegation not in place. Thus, bankruptcy judges have plenary authority over all matters coming within federal bankruptcy jurisdiction. Administratively, most bankruptcy courts operate as independent entities with their own chief judges, clerks, and local rules. Existing statute and judicial conference regulations circumscribe the extent to which administrative services may be consolidated with those of the district court. In reading the jurisdictional provisions of Title 28 dealing with bankruptcy, it is useful to think of district court as meaning bankruptcy court, except where the context clearly requires otherwise. Because of the complete delegation of bankruptcy jurisdiction, it is bankruptcy judges who in the first instance try to parse out the jurisdictional requirements of Section 1334, or determine whether to abstain in a matter or remand it to a state court. On the other hand, there are instances where the statutory context clearly means district court when that term is used, as in the instance of appeals or withdrawal of reference of proceedings from the bankruptcy court or the trial of personal injury or wrongful death claims.
Judge Leonard, isn't it the case that there might be some ambiguity concerning cases involving the debtor that are already pending in the district court when the bankruptcy case is filed? The question that may come up is whether such cases are automatically referred to the bankruptcy court for the district upon the commencement of the debtor's bankruptcy case. Whether the action is one brought by or against the debtor, it would generally fall within the scope of bankruptcy jurisdiction and thus come within the terms of the order of reference. Thus, it would appear that the district court would be divested of its authority over the case. Unless the reference was withdrawn, the bankruptcy court would be authorized to hear it. Because such a situation could be the source of friction between the district court and the bankruptcy court, as well as a source of uncertainty for the parties, some districts have local rules requiring the explicit reference of pending proceedings from the district court to the bankruptcy court. Abstention and the related concept of remand of removed cases are an integral part of the jurisdictional scheme created by the 1978 Bankruptcy Reform Act and the 1984 amendments. In those acts, Congress substantially expanded the subject matter jurisdiction of bankruptcy courts in order to allow them to resolve promptly all proceedings that must be resolved in the course of the bankruptcy case. If, however, state law proceedings can be promptly adjudicated in state court, there may be no need to have the bankruptcy court resolve them. Thus, Congress gave bankruptcy courts broad authority to abstain from hearing or to remand cases arising under state law. In some situations, Congress requires bankruptcy courts to abstain. Mandatory abstention is governed by 28 U.S.C. Section 1334 C.2. That provision requires the district court, and thus the bankruptcy court upon reference, to abstain when certain conditions are present. These requirements are as follows. The proceeding must be based upon a state law claim or cause of action. The proceeding must be non-core, that is, related to a case under Title 11, but not arising under Title 11 or arising in a case under Title 11. The proceeding must be one over which the federal courts would not have had original jurisdiction in the absence of bankruptcy. The state court must be able to adjudicate the proceeding in a timely manner, and at least in some courts, the proceeding must have already been pending in state court at the time the bankruptcy petition was filed. For other courts, it's sufficient that a state action could be commenced and concluded in a timely manner.
It's rare that all of these requirements are met. The mandatory abstention provision has generally been interpreted narrowly, thus leaving the decision to abstain largely to the court's discretion. Furthermore, Congress expressly excluded from the mandatory abstention requirement personal injury, tort, and wrongful death claims against a bankruptcy estate, even though such claims are statutorily declared to be non-core.
Under 28 U.S.C. Section 1334 C.1, bankruptcy courts are given discretion to abstain from hearing any proceeding in the interest of justice or in the interest of comity with state courts or respect for state law. In exercising this discretion, a bankruptcy judge needs to balance concerns for prompt adjudication of the bankruptcy case with the state court's interest in adjudicating its own law. Courts have tended to look at several factors in deciding whether to abstain. First, they consider the nature of the state law question. If the issue of state law is well settled, or the state law issue, though novel, is incidental to the proceeding, abstention is unlikely. Moreover, if the proceeding also presents significant bankruptcy law issues, abstention may not be appropriate. On the other hand, abstention is more likely if the state law issue concerns an area such as domestic relations or land use planning, in which federal courts traditionally abstain in favor of state courts. Two other factors courts have considered in deciding whether to abstain are timing and judicial economy. Often, state courts can't resolve suits quickly enough to ensure prompt administration of the bankruptcy case. Accordingly, abstention is not appropriate. In other situations, where it may not be possible to obtain federal jurisdiction over all claims in a lawsuit pending in a state court, it may be advisable for the bankruptcy court to abstain in order to allow the state court to handle the entire suit. A final factor sometimes considered in ruling on abstention is the congestion of the bankruptcy court. Some courts have abstained from hearing a major state law action when adjudicating it would impede the bankruptcy court's ability to handle core proceedings promptly.
Under Section 1452 of Title 28, a proceeding pending in another court that falls within the bankruptcy jurisdiction may be removed. The procedures for removal are precisely spelled out in Bankruptcy Rule 9027 and are strictly construed. The statute provides that a party may move to remand the case to the court where it originated and gives the bankruptcy court power to remand the matter on any equitable ground. This standard generally involves the same analysis as the decision on abstention. It is a pragmatic and fact-driven decision, often turning on a comparison of the relative speed with which the matter can be reached in the two courts.
Generally, a decision of the bankruptcy court to abstain or to remand a removed case, or a decision not to take such actions, is reviewable only by the district court or bankruptcy appellate panel. Congress has declared that such decisions may not be reviewed by appeal or otherwise by the Court of Appeals or the Supreme Court. The one exception to this rule is a bankruptcy court's decision not to abstain from hearing a matter falling within the terms of the mandatory abstention provision.
In the 1978 Code, Congress gave all bankruptcy jurisdiction directly to the bankruptcy courts. This simple jurisdictional framework lasted 3 years until the Supreme Court decided Northern Pipeline Construction Company v. Marathon Pipeline Company in 1982. The facts of this case warrant brief examination. Marathon was a Chapter 11 case in which the debtor in possession brought a breach of contract action in the bankruptcy court. The defendant had not filed a claim in the bankruptcy proceeding, nor consented to be sued in the bankruptcy forum. The defendant moved to dismiss the action on the grounds that the bankruptcy court lacked jurisdiction. The bankruptcy judge denied the motion. The Supreme Court ultimately reversed, holding that the grant of jurisdiction to the bankruptcy court, an Article I tribunal, was unconstitutionally broad. According to the court, such a traditional state law private right of action must be heard before an Article III judge. After a confusing 2 years, during which most bankruptcy courts operated only on the authority of local rules, Congress in 1984 clarified the situation. In Section 157 of Title 28, Congress delineated the types of matters that may be heard and finally determined by bankruptcy judges. These are known as core proceedings and are generally synonymous with the concept of proceedings arising under and within Title 11. Other proceedings, largely those denominated as related to, are by statute designated as non-core. Questions about the scope of authority of a bankruptcy judge may arise either under the proper application of Section 157 to a particular dispute or under principles of constitutional delegation as explained in Marathon. It is important not to lose sight of the forest for the trees here. The vast majority of matters adjudicated by bankruptcy judges fall within the definition of core proceedings, and there is simply no question about authority to decide the matter. And even in the case of related proceedings, the practice in many courts is for the parties to routinely consent to the full exercise of jurisdiction by the bankruptcy judge. Thus, although the statutory and constitutional analyses lurk in the background, they do not significantly impact the day-to-day work of judges.
In core proceedings under Section 157b2, a bankruptcy judge has full authority. He or she conducts the hearing or trial, enters interlocutory orders, and ultimately awards a final judgment. As more fully discussed later, this judgment is subject to traditional appellate review, either to the district court or to a bankruptcy appellate panel if appropriate. In a non-core proceeding, an outside observer would not perceive the role of the bankruptcy judge as very different. He or she still conducts the necessary hearings and enters interlocutory rulings. However, the bankruptcy judge is limited to submitting proposed findings of fact and conclusions of law to the district court, which are then subject to de novo review rather than traditional appellate deference. Bankruptcy Rule 9033 spells out the specific procedures to be followed when the bankruptcy court hears a non-core matter. Note that under Rule 9033D, the district court is only obligated to undertake a de novo review to those findings and conclusions to which a specific, timely objection is noted. And again, remember that the consent of the parties for purposes of entry of a final judgment and appellate review essentially converts a non-core matter into a core proceeding.
The decision whether a matter is a non-core proceeding is for the bankruptcy judge assigned the matter. Literally hundreds of cases have been decided since Marathon dealing with this classification issue, and candidly, they cannot all be reconciled. Although we will talk in a few minutes about some of the areas where the cases are most sharply split, you will simply have to familiarize yourself with the controlling precedent in your circuit to be on solid ground in this area. In general, courts have construed core proceedings broadly, unless Congress has clearly specified otherwise. On the other hand, courts have hesitated to push the language of Section 157B to its full reach when to do so would run afoul of Marathon. Two general principles seem to underlie the decisions that classify a matter as core consistent with Marathon. First, was it the sort of proceeding that was traditionally determined by bankruptcy referees prior to the enactment of the Code? And even if not, is it a proceeding so integral to the bankruptcy process that it arises under Title 11, even if other state or federal law is incorporated? And finally, note that some proceedings have been classified as non-core as a matter of congressional policy, even if under Marathon they could permissibly be treated as core. Foremost among these are personal injury and wrongful death claims against the estate, which are subject to mandatory withdrawal to the district court. Similarly, cases that require the bankruptcy court to interpret federal statutes regulating organizations or activities affecting interstate commerce are subject to mandatory withdrawal. In practice, the ambiguity of the reach of this latter section has caused it to have little effect. There are three areas where the distinction between core and non-core has been particularly troublesome. The first comes with accounts receivable. Some courts have treated the estate's right to the accounts as a discrete property interest, subject to turnover as a core proceeding. Others have viewed it largely as a breach of contract action that is indistinguishable from Marathon, and thus must be non-core. Unless there has been an adjudication prior to the bankruptcy, it is difficult to see how this is anything other than a non-core proceeding under Marathon.
A second area of difficulty has come with fraudulent conveyances. Prior to the Code, these were not proceedings that could be adjudicated by the referee. Rather, the trustee was required to go to other courts and sue. Nonetheless, these are proceedings that clearly now arise under Title 11, and circuits have held that this is sufficient to classify them as core. However, as will be explored more fully later, this analysis has been muddied by the Supreme Court's holding that despite the classification as core, a defendant in a fraudulent conveyance action may retain a right to a jury trial. Thus, without the express consent of all of the parties to a jury trial in the bankruptcy court, the bankruptcy court cannot try the case and enter the final judgment, even though the proceeding is by statute labeled core.
And finally, there is some ambiguity about the extent to which proceedings by the estate against a creditor who has filed a claim in the bankruptcy are core. The statute expressly makes them so, and at least to the extent that the estate's claims would be a compulsory counterclaim, there seems to be little argument. Whether a permissive counterclaim by the estate can be treated as a core proceeding is an open matter. Virtually all courts have now held that bankruptcy judges have the power to enter orders of civil contempt. The courts are split on the issue of whether orders of criminal contempt are permissible. Bankruptcy Rule 9020 sets out the preferred procedures for handling a contempt proceeding. Under it, A contempt committed in the presence of the court may be determined summarily and an order entered. In other situations, the court must give written notice of the precise facts concerning the contempt, inform the respondent whether the contempt is civil or criminal, and provide an opportunity for hearing. Note that if the alleged contempt involves disrespect or criticism of a particular judge, another judge must hear the contempt proceeding unless the respondent consents. Also note that under Rule 9020, an order adjudicating contempt is not effective until 10 days after service on the party held in contempt, to provide an opportunity to seek appellate review. If review is sought, the order is stayed, pending decision on review. Of course, contempt is not the only manner in which the court may deal with recalcitrant parties or attorneys. Sanctions may be imposed under Bankruptcy Rule 9011 or 7037, under provisions of Title 11 that specifically authorize the imposition of sanctions, such as Section 362H for willful stay violations, or under other provisions of federal law.
The discussion of jury trials in the bankruptcy court involves two distinct issues. When is there a right to a jury trial in a bankruptcy proceeding, and under what circumstances may a bankruptcy judge conduct a jury trial? Fortunately, in recent years, Congress has provided statutory guidance concerning the latter issue. The first issue remains complex and somewhat uncertain. Determining the existence of a right to a jury trial in a bankruptcy proceeding usually requires a constitutional analysis. The only statute addressing jury trial rights in bankruptcy, 28 U.S.C. Section 1411, appears to confer such rights only with respect to personal injury and wrongful death tort claims. For all other matters, the only possible source of a right to a jury trial is the Seventh Amendment. In its 1989 Grand Financiera v. Nordberg decision, the Supreme Court held that a defendant to a fraudulent conveyance action in the bankruptcy court who had not filed a proof of claim against the bankruptcy estate had a Seventh Amendment right to a jury trial. The court reached this conclusion by applying a two-part analysis that combined traditional Seventh Amendment analysis with a consideration of whether Congress had authority to eliminate jury trial rights through its assignment of the matter for resolution in the bankruptcy court. The first step of the analysis requires a determination of whether the proceeding involves legal as opposed to equitable claims and remedies. If so, then such proceeding, had it existed in 1791, would have been heard by a court of law and would have been triable by a jury. Thus, the Seventh Amendment preserves that right, unless Congress, through its forum assignment, may eliminate it. According to the Supreme Court, the answer to that question depends upon whether the proceeding involves public or private rights. Only if a proceeding involves public rights may Congress eliminate a right to a jury trial by assigning the proceeding to a non-jury forum. In Grand Financiera, the court held that the fraudulent conveyance action before it, brought against a defendant who had not filed a proof of claim in the bankruptcy, involved private rights. But the court's opinion provided relatively little guidance about how to analyze the nature of other proceedings. In a subsequent per curiam opinion, the Supreme Court gave further explanation of the significance for jury trial purposes of a creditor's filing of a proof of claim. According to the court, such creditors bring themselves within the equitable jurisdiction of the bankruptcy court, and thus they have no constitutional right to a jury trial of the claim itself or of any counterclaims asserted against them by the trustee. While the precise scope of jury trial rights in bankruptcy remains somewhat unclear, some things are certain. Claims against the estate are not entitled to a jury trial, except in the limited situation covered by Section 1411. The filing of a proof of claim can eliminate jury trial rights. If equitable relief is sought, for example, an injunction, restitution, or specific performance, there is no right to a jury trial. Whether the proceeding is core or non-core is not determinative of the existence of a right to a jury trial, and jury trial rights can be waived. Who conducts a jury trial in a bankruptcy proceeding if there is such a right? The Bankruptcy Reform Act of 1994 provided an answer to that question. Under 28 U.S.C. Section 157E, a bankruptcy judge is authorized to conduct a jury trial in a proceeding that otherwise can be heard by a bankruptcy judge if 1, the district court specially designates the bankruptcy court to exercise such jurisdiction, and 2, all the parties to the proceeding give their express consent. Judge Leonard, what happens if both of those requirements are not satisfied?
Of course, the ultimate conclusion is that the jury trial must take place in the district court. However, there is no reason the case cannot remain with the bankruptcy judge for case management and resolution of pretrial matters. For instance, in my district, the district judge does not withdraw the reference until all pretrial motions are resolved and the final pretrial order is entered. The shift of jurisdiction from the bankruptcy judge to the district judge can occur at any point in the case and requires close coordination between the two. The unique nature of bankruptcy cases make bankruptcy appellate practice somewhat distinct. Unlike a typical lawsuit where there is a clear winner and a clear loser, a decision in a bankruptcy case may impact a number of entities to differing degrees. The courts have generally been flexible in their approach to standing, allowing any party to appeal whose pecuniary rights are directly affected by the ruling. However, a party that has sat silently by in the bankruptcy court may not appeal. Standing still requires that the appellate have appeared and objected in the bankruptcy court. Under Section 158A of Title 28, appeals may be taken from final judgments, orders, and decrees, interlocutory orders which increase or reduce times for filing a plan in a Chapter 11 case, and other interlocutory orders with leave of the district court or bankruptcy appellate panel. Finality in the bankruptcy context is given a pragmatic interpretation. It does not require that a case under Title 11 be completely concluded for rulings to be final for appellate purposes. Rather, the courts acknowledge that a bankruptcy case is a collection of discrete disputes resolved over the life of a case. An order is understood to be final if it resolves all of the issues surrounding a particular dispute, including the scope of relief, even though the underlying case continues on. Also, the collateral order doctrine is generally applicable in bankruptcy cases. Under this doctrine, a ruling is treated as final if it conclusively resolves a disputed question, the issue resolved is separate from the merits of the underlying action, and the order would be effectively unreviewable if it awaited conclusion of the case. Examples of orders held to be final are in your outline.
Other than interlocutory orders reducing or increasing the time for filing a plan in a Chapter 11 case, interlocutory orders are appealable only with leave of the appellate court. Generally, an interlocutory order is one that operates procedurally and does not reach the merits of a dispute, or partially addresses the merits of a dispute but does not finally dispose of it. Again, examples of orders determined to be interlocutory are included in your outline.
An appeal from a bankruptcy court may take one of two distinct paths. Historically, appeals have gone to the district court, of which the bankruptcy court is a unit. A single judge hears them there. However, Section 158B1 authorizes the circuits to create bankruptcy appellate panels, known as BAPs. At the current time, 6 circuits have created BAPs. In these circuits, the litigants may consent to take their appeal to the BAP. Bankruptcy judges assigned to the BAP from throughout the circuit sit in panels of 3. However, no bankruptcy judge may be a member of a panel hearing an appeal from his or her district. Even where a BAP is authorized for a circuit, appeals from a particular district within that circuit do not go to the BAP unless a majority of the district judges so authorize. Although an appeal to the BAP must be with the consent of all parties, note that where a BAP is in operation, consent is presumed. A party who desires to appeal to the district court must so indicate during applicable time periods. Decisions of the district court or BAP on bankruptcy appeals may in turn be reviewed in the appropriate circuit court. The law is unsettled about the extent to which a matter decided by the district court or BAP may be immediately appealed to the circuit court. Some circuits hold that if the bankruptcy order was itself final, then the appellate ruling is final without further analysis and may be appealed immediately. Other circuits look to the effect of the ruling on appeal. If it remands the matter to the bankruptcy court where significant further proceedings are required, the order is deemed interlocutory. You should familiarize yourself with the precedent in your circuit. The standard of review on appeal is the familiar one. Findings of fact of the bankruptcy court will not be overturned unless clearly erroneous. Conclusions of law are reviewed de novo. Finally, bankruptcy appeals move swiftly. Unlike the more leisurely 30 days allowed for appeal in other federal litigation and under the practice of many states, a notice of appeal from a bankruptcy ruling must be filed with the clerk of the bankruptcy court within 10 days of the entry date of the ruling. The bankruptcy court may briefly extend this time if a request is made during the 10 days, or if a motion demonstrating excusable neglect is filed within the subsequent 20 days. Also note that there are 6 categories of final orders for which the appeal time may not be extended for any reason. These are listed in your outline.
Bankruptcy courts have been given broad subject matter jurisdiction so that they can resolve most matters that need to be resolved in the course of administering a bankruptcy case. Gone are the days when the closing of bankruptcy cases frequently had to await the resolution of proceedings by state or federal district courts. Although the jurisdictional and organizational scheme is complicated as a result of constitutional concerns arising from the non-Article III status of bankruptcy judges, in the large majority of proceedings, the bankruptcy judge's authority is clear. Day in and day out, bankruptcy judges resolve the matters that arise in bankruptcy, knowing that they have been granted the authority needed for an expeditious conclusion of the cases before them.